Closer to home, the families of 9 Camp Mystic campers are suing Texas for allowing the camp to operate despite lacking a required evacuation plan. Last summer, 27 campers and counselors were killed after raging floodwaters swept through the camp on July 4th. The lawsuit targets the state's Department of State Health Services and some of its officials. It claims that the lack of an evacuation plan caused camp staff to panic as floodwaters rose. A spokesperson for DSHS says it does not comment on pending litigation. Now, in a letter, Texas Lieutenant Governor Dan Patrick urged the state agency not to issue a 2026 license to Camp Mystic. In a statement, the camp says it plans to reopen this summer at a new location on Cypress Lake, adding there is no regulatory basis to deny its new license. For more on this, I'm joined now by NBC News legal analyst Misty Marris. Misty, good to have you with us. So, this lawsuit was filed in federal court earlier this week. It named 6 Texas state health officials who oversee the youth camp program and Camp Mystic's inspector. It doesn't name the camp itself. What's the core legal argument the families are making?
So this is a different legal argument than we've seen with many of the lawsuits that have come out of Camp Mystic. So this is based on Section 1983, which is a federal statute that allows for a plaintiff to bring a lawsuit against a government employee or a government entity when there was a deprivation of civil rights, deprivation of a constitutional right. Here, the allegation is that they were the campers that are deceased, their families are now seeking redress, that they were denied substantive due process. And the crux of the argument is that these officials, the 6 officials who are defendants, allowed the camp to continue to operate without complying with the state law, which included an evacuation plan. So these individuals are alleged to have direct involvement in that, which resulted in the death of these 9 campers.
The suit claims that an inspector actually visited the camp just 2 days before the flood, confirmed it had a written disaster plan, also alleges that emergency guidance was to stay inside, even though the cabins were in designated flood zones along the river. Based on what's filed here, what you've seen, how strong do you think this case is?
So on its face, it seems like this is going to be one that's going to go through the litigation process. It's important to note that there are extra protections written into the law when you sue a state or you sue somebody who is an employee of the state acting in their official capacity. There's what's called qualified immunity. It generally shields those individuals from civil liability. But the analysis is whether or not they acted with deliberate indifference. That means there was a known risk and they basically ignored it, and they knew that that could cause significant harm and damage. So the defense actually in this case could be different with respect to these 6 individuals, depending on the role that they played in accordance with issuing these licenses. Now, keep in mind, another defense will be that this was an unprecedented disaster. So this is going to play out in the litigation process.
Texas lawmakers are expected to have hearings on this spring. Real quick here, I would have to imagine anything someone says in a public hearing could be used in this case or could prompt other cases to follow, right?
Yeah, obviously this is a horrific tragedy, and what those investigations are going to conclude, ultimately there'll be a report which says what went wrong and why, what could have been done better, where the laws were potentially violated. So the outcome of those investigations and ultimate conclusions could impact not just this civil case we're talking about today, but all of the pending cases and potentially spur new litigation.
All right, Misty Marris, appreciate your analysis. Thank you so much.